Good afternoon and welcome. I'm Congressman Dennis Kucinich, Chairman of the Domestic Policy Subcommittee of Government Reform and Oversight. I'm joined today by the ranking member of the committee, Mr. Jordan of Ohio. Our hearing today is Arbitration or Arbitrary, the misuse of mandatory arbitration to collect consumer debts. The subject of this hearing, the use of mandatory pre-dispute arbitrations as a method of obtaining judgments for consumer debts, is not what we normally think of when we hear the terms arbitration or consumer arbitrations. We're not talking about arbitrations brought by consumers against businesses, and we're not talking about individual arbitrations brought by businesses against consumers. We're talking about mass production arbitrations where businesses file thousands of claims against consumers to obtain judgments on credit card debt, where the claims are assigned to arbitrators in batches of dozens, where the consumer almost never appears or even responds, and where the so-called hearing consists of nothing more than the arbitrator looking at a statement written by the creditor and awarding the amount that the creditor requests. Over the past few months, the Domestic Policy Subcommittee has conducted an investigation into the actual practices of the two largest providers of consumer arbitration services, the National Arbitration Forum, known as the NAF, and the American Arbitration Association, the AAA. NAF is by far the #1 generator of arbitration awards against credit card customers. The AAA also administered consumer debt collection arbitrations and state that they have stopped doing this as of June 2009. Subcommittee staff reviewed over 50,000 pages of documents, including hundreds of actual case files, to determine how the claims were decided by the arbitrators. Our investigators have come to several deeply disturbing conclusions about the National Arbitration Forum's arbitration system. Who wins or loses an NAF arbitration seems to depend solely on which arbitrator reviews the claim. As part of our review, subcommittee staff compared 228 nearly identical NAF consumer debt collections claims, and we found that 3 arbitrators granted awards in favor of the debt collection firm nearly 100% of the time, while 2 arbitrators reviewing otherwise identical claims dismissed those claims nearly 100% of the time. Our review of these files found absolutely no reason in the case files to explain such inconsistent results. We also found that some of NAF's arbitrators either don't know the rules they're supposed to follow or they don't follow them, and nobody at NAF seems to care. One NAF rule establishes a limit to the amount of time between filing of the claim and service of notice on the consumer debtor. Our investigation found that NAF does not require its arbitrators to adhere to this rule. Out of a total of 172 consumer debt collection claims that could have been dismissed under those rules, none were. What's more, NAF is also violating a California law by refusing to publish the results of many of its arbitrations with residents of that state. Our investigation further revealed that this violation is allowing at least one debt collection company to obtain awards of attorney's fees that exceed legal limits. The subcommittee staff's findings support a considerable body of evidence showing NAF's misuse of mandatory arbitration in debt collection cases. Last week, the Attorney General of the State of Minnesota filed a lawsuit against the NAF alleging violations of Minnesota's consumer fraud statute and other claims based on NAF's concealment of its ties to creditors. its active solicitation of creditors based on promises of providing leverage over consumers, its direct financial affiliation with one of the country's largest debt collectors. Remarkably, just this past Saturday, the NAF agreed to a settlement with the Minnesota Attorney General in which it would immediately stop all arbitration proceedings that are the subject of this hearing. The settlement does not admit wrongdoing, however. NAF still maintains that its arbitrations and arbitrators are fair and independent. Our investigation strongly suggests otherwise, and we will hear from the NAF, Public Justice, and from the Attorney General of Minnesota herself, the Honorable Ms. Lori Swanson, on the supposed neutrality of NAF arbitrations. The hearing today will also address other systemic problems the subcommittee investigation found with this arbitration system, such as why the right to appeal a decision in consumer arbitration claims is limited to a finding of fraud or corruption, the lack of oversight of the claims process itself, and the bias built into arbitrations favoring the debt collection industry. Now, defenders of this mass production arbitration system argue that abolishing it will only raise the cost of litigating debt collection cases. But consumers have rights and protections under the law that are not honored in the arbitration setting. Furthermore, the number of Americans who have experienced the suspension of their rights due to consumer arbitration has grown as the number of consumers with debt has exploded. Today, the average adult carries over $4,000 of debt. The debt collection industry and the alternative legal system that's been created around it can no longer be ignored by the federal government. Others seem to agree with us. There are a number of bills in Congress that would impose limits on the applicability of mandatory pre-dispute arbitration agreements, including one introduced by our colleague, Representative Hank Johnson. Very significantly, Congressman Barney Frank, chairman of the Financial Services Committee, has introduced a bill to establish a new consumer protection agency which would have the power to limit or ban mandatory pre-dispute consumer arbitration agreements. And the Federal Trade Commission is currently evaluating the entire system of debt collection, including arbitration practices, with an eye towards the much-needed modernization of debt collection laws. I hope this hearing will bring increased awareness to the problems of the mandatory consumer debt arbitration system, hold those accountable that have abused consumers' rights in the past, and explore solutions to improve the system so it's no longer a one-stop shop for debt collection agencies to obtain a binding legal judgment against the consumer. Our citizens deserve nothing less. At this time, prior to recognizing Mr. Jordan, I just want to observe the presence of our colleague from Maryland, Mr. Cummings. Thank you for being here. And our colleague from California, Ms. Watson. Thank you for being here. And Chair recognizes Mr. Jordan. His opening statement. You may proceed.
Thank you, Mr. Chairman. The challenges consumers face in troubled economic times only underscore the importance of this hearing. This particular hearing provides an excellent opportunity to discuss and debate mandatory arbitration clauses. This is an important matter, and I look forward to having a productive discussion on the many issues surrounding consumer arbitration. As we debate President Obama's proposed Consumer Financial Protection Agency, we must think hard about the way this new agency would operate. Mr. Obama's existing proposal is the latest of the administration's expanding its reach into the private sector. I'm particularly concerned that under the new agency, the administration would have the authority to eliminate mandatory arbitration clauses. This is simply bad policy. Well-respected academics and experts agree arbitration is fair, equitable, and necessary. In 2007, Professor Peter Rutledge told the Senate Judiciary Committee that in a world without pre-dispute arbitration, consumers would face higher costs. Professor Rutledge explained the only people who with certainty benefit from the Arbitration Fairness Act are the lawyers. Frankly, it's the undisputed fact that this is primarily the trial lawyers that stand to benefit from the elimination of arbitration clauses. During a House Judiciary markup, Representative Hank Johnson claimed mandatory pre-dispute binding arbitration clauses leave consumers without choices. But these choices have nothing to do with consumer rights as much as tactics for lawyers to make money. Representative Johnson stated, quote, "You can't influence large corporations by being nice. You need a jury to get into their pocket," close quote. Unfortunately, justice is sometimes the price you pay. 2008 Mississippi lawyer Dickie Scruggs pleaded guilty to conspiring to bribe a judge and is currently serving a 7-year sentence in federal prison. Bill Eric and Mel Weiss are each serving time in jail for a criminal conspiracy of paying millions of dollars in illegal kickbacks to lead plaintiffs in a class action lawsuits in order to help the lawyers win the race to the courtroom. Kentucky plaintiffs' lawyers William Gallion and Shirley Cunningham Jr. were jailed in order to pay disgorgement of the $30 million they scammed from their clients in settlement over the diet drug FinFin. The point I'm making is just because you have a few bad apples, you don't throw out the whole barrel. If it's true for lawyers, it's also true for arbitration. Today's oversight hearing is set to focus on consumer arbitration, not the evils of business. If, for example, credit card companies are harming consumers, then a separate hearing is needed. Statistics citing that consumers overwhelmingly lose in debt collection cases do not support the notion that arbitration is the enemy. By way of example, the federal government wins nearly all of its cases to recover unpaid student loan debt. Is the federal government to blame when debtors lose? Is arbitration? Today's hearing should foster debate on policy directly related to mandatory arbitration. Whether or not arbitration, which provides a dispute resolution service, is good or bad for consumers is an inquiry independent from whether debt collection as a business is bad for consumers. Consumers have successfully used arbitration to resolve disputes with businesses. Debt collection may present serious problems to consumers, but the best evidence available would indicate that those problems are worse in litigation than in arbitration. It is my hope that the members here today can help our witnesses tailor this hearing to the empirical data available concerning debt collection and consumer cases. Only then can we make progress in providing remedies to consumers. A flat-out elimination of mandatory arbitration is not the answer. To that end, I hope today's discussions also examine feasible alternatives to remedy the issues at hand. I'm also concerned, Mr. Chairman, that 3 of the 4 witnesses called today by the majority have benefited from a lawsuit and successful settlement with the majority's 4th witness, the National Arbitration Forum. This may not prohibit us from having a productive hearing, but it is certainly a fact worth noting. Thank you, Mr. Chairman, for holding this important hearing today. The issues not only affect our home state of Ohio, but also the entire United States. And I look forward to hearing from our witnesses. Excuse me, Mr. Chairman, I would also ask unanimous consent for the minority staff report be included in the record.
Without objection.
Mr. Chairman, I'd also ask for unanimous consent that a statement received from ACA International and an email be included in the hearing record as well.
I'd ask the gentleman, do we have the email?
Yes, we do, right here.
Okay. Okay. Without objection.
Thank you, Mr. Chairman.
And without objection, members and witnesses may have 5 legislative days to submit a written statement or extraneous materials for the record. Without objection, at some point we will welcome Representative Hank Johnson to the dais to make a statement if he comes in time, receive testimony, and participate in the questions. And without objection, all members will have 3 minutes. Opening statements not to exceed 3 minutes. I'm also, without objection, Mr. Jordan, without objection, we're also going to put the staff report of the Democratic Policy Subcommittee majority staff on arbitration abuse in the record.
How's it going?
The chair recognizes a gentleman from Maryland, Mr. Cummings, for a 3-minute statement.
Mr. Chairman, thank you for calling this hearing, and I will just submit a written statement. Thank you very much.
I thank the gentleman. The chair recognizes Ms. Watson of California for an opening statement.
Thank you, Mr. Chairman, for holding today's important hearing to evaluate whether consumer debt collection arbitration, as currently administered produces results that are fair to both businesses and consumers. Today, virtually all consumers, often unknowingly, enter into mandatory arbitration agreements, forging their right to regular court proceedings as part of the fine print of consumer, employment, and franchise agreements. While some contend arbitration offers consumers a more cost-effective procedure with all the protections of a traditional litigation procedure, the investigation of this committee and the case brought by the Attorney General of the State of Minnesota against the National Arbitration Forum have revealed significant concerns about the neutrality of the arbitration process for consumer debt collection. A June 5th cover story in Business Week magazine entitled "Banks versus Consumers, Guess Who Wins?" describes the business practice of the National Arbitration Forum, which dominates credit card arbitration and operates in a system in which it is exceedingly difficult for individuals to prevail. I'd like to enter this particular report to the record.
Without objection.
Internal documents discussed in the article describe NAF's marketing pitches to credit card companies where they depict their arbitration services as favorable to businesses with a promise, marked increase in recovery rates over existing collection methods. Rather than providing the neutral resolution service they portray to the public, in these confidential documents, the NAF describes the benefits of pro-business hasty arbitration with little to no mention of the rights or concerns of the consumer. Elizabeth Bartolet, a Harvard Law School professor and former arbitrator for NAF, is quoted describing their practices as a process that systematically service the interests of credit card companies. So today's hearing comes at a very critical point. With unemployment at 9.5% nationally and 11.4% in my district in Los Angeles, California, and $928 billion worth of outstanding credit card debt in the United States as of May 2009, it is imperative we gain meaningful insight into how we can improve this process and empower American consumers with the ability to fairly manage their consumer obligations. So, Mr. Chairman, I look forward to today's testimony, and I yield back.
I thank the gentlelady. Chair recognizes Mr. Foster. You may proceed for 3 minutes.
Thank you, Mr. Chairman. Today's hearing follows months of extensive investigation by this subcommittee into hundreds of cases of consumer debt collection arbitration. But it is timely, coming less than 1 week after the National Arbitration Forum agreed to stop accepting all future consumer arbitrations. The settlement in Minnesota is instructive, but it's not the end of the story. The authority for commercial arbitration originated in the Federal Arbitration Act, a 1925 law that may well be out of date and in need of significant improvement. It is this panel's duty to uncover and work to correct flaws in arbitration proceedings. I look forward to hearing from all our witnesses on pragmatic solutions that will ensure consumers as well as businesses are dealt with fairly, and it's my hope that this committee will work swiftly to implement them. It may also be useful to view today's hearing in the context of wider financial reform. The patterns of collusion that we will hear about today seem not unlike the conflicts of interest that have emerged, for example, between credit rating agencies and the issuers of instruments that they rate. The challenge of this Congress will be to devise fair and workable reforms to our financial system that ensure that neutral parties are in fact neutral, and to ensure that consumers as well as businesses are protected. Thank you, Mr. Chairman, and I yield back.
I thank the gentleman. If there are no additional opening statements, the subcommittee will receive testimony from the witnesses before us today. I want to start by introducing our panel. Ms. Lori Swanson, welcome. is the Attorney General of the State of Minnesota. Ms. Swanson was elected Attorney General of the State of Minnesota in 2006 and previously served as Solicitor General and Deputy Attorney General from 1999 to 2006. Attorney General Swanson's legal actions, legislative efforts, and consumer advocacy have helped to level the playing field on behalf of ordinary citizens. She drafted and helped secure the enactment of a predatory mortgage lending law in 2007 that has been nationally heralded as a model for other states. She has sued cell phone companies, many of which use mandatory arbitration clauses for extending people's contracts without their permission, then charging hefty early cancellation penalties when they tried to cancel. She's also sued collection agencies for trying to trick citizens into paying debts they do not owe. On July 14, 2009, Attorney General Swanson filed a lawsuit against the National Arbitration Forum, alleging that it misrepresented its independence and hid from consumers and the public its extensive ties to the collection industry. On July the 17th, she entered into a landmark settlement with the National Arbitration Forum. She has publicly expressed concern about the growing use of mandatory arbitration clauses in credit card, cell phone, and mortgage contracts. Mr. Michael Kelly, welcome. Mr. Kelly was until recently the Chief Operating Officer of the National Arbitration Forum, where he oversaw all operational and legal matters. He is now Chief Executive Officer of Forthright, an entity spun off from the NAF in late 2007, which handles all administrative matters for the National Arbitration Forum. Previously, he held executive positions with the Minnesota Vikings and Gander Mountain and was a partner at the Minneapolis law firm Faegre and Benson. Mr. Kelly served for 8 years on the Edina, Minnesota City Council and was the Mayor Pro Tem and Vice Chair of the Housing and Redevelopment Authority. He has served on the board of the Minneapolis Downtown Council and the board of the Minnesota Opera. Mr. Richard W. Neymark. Welcome, Mr. Neymark. He is the Senior Vice President in the for the International Center for Dispute Resolution, a division of the American Arbitration Association, where he has overall responsibility for international issues and government relations. He's the founder and former executive director of the Global Center for Dispute Resolution Research. Mr. Neymark is an experienced mediator and facilitator, having served as a neutral in a wide variety of business and organizational settings. His experience includes work with the United Nations, government, universities, corporate, construction, insurance, and nonprofit areas. Mr. F. Paul Bland. Mr. Bland, welcome. Mr. Bland has been a staff attorney at Public Justice since 1997 and is responsible for developing, handling, and helping public justices, cooperating attorneys litigate a diverse docket of public interest cases. He has argued and won more than 20 cases that have led to reported decisions for consumers, employees, or whistleblowers in 4 of the U.S. Courts of Appeals and the high courts of 6 different states. He is currently handling or assisting with appeals before the U.S. Court of Appeals for the 11th Circuit, the California, Florida, Kentucky, and Nevada Supreme Courts, and the Maryland Court of Appeals. Finally, Professor Christopher R. Drahozl. Welcome, Professor. Professor is it Dre or Drahozl? Drahozl is the John M. Rounds Professor of Law, University of Kansas School of Law. He is chair of the Arbitration Task Force at the Searle Civil Justice Institute at Northwestern University School of Law. The professor has written extensively on the law and economics of arbitration. He's authored a case book on commercial arbitration and co-edited a book on empirical research on international commercial arbitration. Prior to teaching, Professor Drahozl was in private law practice in Washington, D.C., and served as a law clerk for the Iran-U.S. Claims Tribunal and the United States Supreme Court and the United States Courts of Appeal for the Fifth Circuit. I want to thank each and every one of our witnesses for appearing before our subcommittee today. It is the policy of the Committee on Oversight and Government Reform to swear in all witnesses before they testify. I would ask at this time if you would rise and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you very much. Let the record reflect that each of the witnesses answered in the affirmative. I ask that each of the witnesses now give a brief summary of their testimony, and to keep this summary under 5 minutes in duration. Bear in mind that your complete written statement will be included in the hearing record, so don't feel that you have to do a 10-minute speech in 5 minutes. I tried that once as a witness many years ago, and it was not fun. But we'll get all of your statement in the record. Let's start the discussion right now. Attorney General Swanson, you're recognized for 5 minutes. Thank you.
Chairman Kucinich, Ranking Member Jordan, members of the committee, thank you for the opportunity to appear here before you on this very important topic of mandatory arbitrations. You know, the right to have disputes resolved impartially is something that we as Americans value very much. Yet millions of Americans are giving away that right without even knowing it. Credit card companies, cell phone companies, lenders routinely bury in the fine print of contracts that may run upwards of 25 or 30 pages long these mandatory pre-dispute arbitration clauses. And consumers don't know it, and oftentimes the clauses come to the consumer not even in an initial agreement, but after the fact, maybe in an envelope stuffer. And even if the consumer doesn't see it, largely they're deemed to be bound to it. We filed a lawsuit against the National Arbitration Forum in Minnesota. We attached a copy of the complaint to the testimony submitted, so I won't go through all of it. But the bottom line is that the National Arbitration Forum represented to the public, to consumers, to the courts, to the government, that it was independent and neutral and operated impartially and like a court system, when in fact it had ties to the very industry that brought claims before it. And those ties really came two ways. First way the ties came was what I would call backroom hustling, going to the credit card companies and the banks and so on and so forth, and asking the lenders to put into the fine print of these contracts mandatory arbitration clauses, and paying executives commissions when they put clauses into those contracts, and then having other executives who were paid commissions to convince those very corporations to file claims against the consumer in the interest of the creditors against the interest of the consumer. In addition, far from the impartiality represented to the consumers, marketing materials given to the credit card companies said things like the customer doesn't know what to expect from arbitration and they're more willing to pay. Or in arbitration, they basically ask you what it is and then hand you the money. In addition to that, we found evidence that the company in some cases drafted claims, the equivalent of a summons and complaint in a court of law, on behalf of the creditor to be filed against the consumer, that in some cases creditors were advised what their legal rights were when consumers weren't. In fact, we heard from employees who said that when consumers did call, people were instructed to really try to get them off the phone as quickly as possible, and even in some cases not to pass on a consumer's answer or information to the arbitrator. We also heard from arbitrators who felt that they were deselected, so that they had been appointed by the company to handle claims, but when they didn't rule for the creditor or give the creditor everything it wanted, or if they terminated or didn't, in some cases, ruled for the consumer, that they were deselected or taken off the panel. And then, in addition to that, we found that the National Arbitration Forum is really part of one big debt collection conglomerate, that you have a New York hedge fund called Accretive that essentially owned a $42 million stake in the National Arbitration Forum outfit, and at the same time that it owned a debt collection law firm called Axient, which in turn owned and acquire the debt collection operations of a law firm called Mann Bracken, which is just about the biggest debt collection law firm in the country. So basically, having this hedge fund controlling the two sides of the equation, or involved in the two sides of the equation, the debt collection side and then as well the arbitration side. Something that we did learn in connection with the investigation that I find troubling and gets a bit far afield is that the Small Business Administration in 2004 gave Accretive $100 million, and in 2008 the Accretive Small Business Investment Corporation ended up purchasing about 7.5% of Axient. And then in 2009, it asked the Small Business Administration for permission to purchase even more of Axient. So essentially, it appears using Small Business Administration money to fund a debt collection enterprise that then treats consumers in an unfair fashion. It's troubling to me if the Small Business Administration believes that its mission is to finance the acquisition of debt collectors who acquire bank debt from bailed out national banks and then use the funds to go after citizens through the types of questionable debt collection techniques we outlined in the complaint. We asked the Small Business Administration for records. They produced, after consulting with the hedge fund, 18 pages, largely blacked out. I couldn't get to the bottom of it. Maybe this Committee on Oversight can, and I would encourage you to follow up on, is SBA money going into this type of enterprise? They basically blacked out almost every meaningful word.
Duly noted.
The
gentlelady's time
I'm expired. Okay.
Expired.
Thank you.
Would you like to just wrap it up?
Just to wrap up, we interviewed over 100 consumers. The case and our concerns go beyond the National Arbitration Forum. There are real concerns with mandatory pre-dispute arbitration clauses and consumers forfeiting their rights without knowing it, and the repeat bias that comes in when corporations essentially select their judge. Thank you.
Thank you very much. Chair recognizes Mr. Kelly. You may proceed for 5 minutes. Thank you for being here.
Thank you, Chairman Kucinich, Ranking Member Jordan, members of the committee. I appreciate the opportunity to be here today. I want to reiterate we have withdrawn the National Arbitration Forum from handling consumer arbitrations pursuant to an agreement with the Attorney General. That being said, it's our continued belief that the forum's exit from this business and the loss of consumer arbitration broadly would represent a significant loss to the consumers that you're seeking to protect. The logical conclusion of this decision is that the consumer cases will all now be brought in court. Initially, I'd like to explore the consequences of that prospect. For those who haven't been to small claims and conciliation court, which I have, it is not often a pleasant experience. In that case, the notice, the response procedures can be very complicated. There's often no representation. Days off of work are required. You sit in a cattle call with hundreds of other people waiting for your opportunity to be heard, and your public financials and issues are revealed for all to see who are there in court. It's not particularly a pleasant experience. It's one that was outlined and discussed significantly in a Boston Globe article in 2006, which I think is pertinent here. In that article, the Boston Globe found in Massachusetts that the courts were stacked against the average consumer. If I can read from the article, it says that many small claims courts have effectively become accomplices of collection firms, routinely giving them the upper hand in court cases while casually disregarding the rights and dignity of ordinary citizens. Collectors almost always win the lawsuits they file without being asked for evidence that the debts they are chasing are actually owed. Debtors frequently receive no notice of the lawsuits against them. The disabled, elderly, and working poor are often talked into repaying debts from government checks, which are, by law, protected from judgment. I quote here, "The creditors are all repeat players. They know exactly how the game works," said Elizabeth Warren, a Harvard Law School professor who studies consumer debt. We're watching a fight between two players, one a skilled repeat gladiator and one who's thrown into the ring for the first time and gets clubbed over the head before they even get a sense of what the rules are. That's the court we're talking about. These cases don't go in front of juries. They go in front of small claim and conciliation courts. Now, what is the difference with arbitration? I can only speak to the difference of arbitration before the forum as it was conducted. And these are some of the fundamental differences. Under the forum rules, responses can be in simple, plain English in whatever form the consumer chooses. Hearings are flexible on their own time of the consumers. They can be handled on the paper, by telephone, or by participatory hearing in the federal jurisdiction in which they live. They're affordable. There's no cost to respond, and to file the cost is only $19 to $40 on average. They're fair. The cases are decided on the merits by retired judges and lawyers with approximately 15 years of experience. And on the merits, there's a critical distinction between the courts that we need to make. Cases in front of the forum, as they were conducted, required the judge, regardless of whether the consumer is present, to look at the merits and decide the case on a matter of law. That is not the same as a default judgment in court. Decisions in arbitration are also confirmed by the court before they are binding, which again is a court of last instance. The purpose of the comparison is to point out that there are very real and meaningful consequences to the elimination of consumer arbitration. We're no longer part of that fight. But I think it's important to note these consequences and the impact of reversing or changing over 80 years of law under the Federal Arbitration Act would have. I would urge that the discussion should center around two very basic questions. First, why? And second, what are the two true due process issues? I say why because from the results we've seen, from the studies we've seen, if the same subject matter is shown, and there are obviously people who can speak to this better than I, the results in court are the same as the results in arbitration. Due process is truly the heart of the matter. It needs to be studied. Due process protection should be made. The ground needs to be leveled for everyone who will practice in this field. But if that is evaluated by this committee and this Congress, we're confident that consumer arbitration will not be eliminated and should not be eliminated. Choice should be provided to select arbitration or court, and due process measures should be allowed and made uniform so that everyone has equal access to affordable justice. Thank you, Mr. Chair.
I thank the gentleman for his testimony. The chair recognizes Mr. Neymark. You may proceed.
Thank you, Chairman Kucinich, Ranking Member Jordan, other members of Congress and the committee. First, I must stress, and I'm sure you'll understand, the American Arbitration Association is a not-for-profit service organization founded in 1926. We've been around for over 83 years. The AAA does not represent or speak for any other organization, but rather we speak only from our own experience over these 83 years. From the beginning, the AAA has drafted rules and procedures for fair and balanced dispute resolution. Our many sets of rules and procedures have been scrutinized by the courts at all levels. As early as 1951, we established with the American Bar Association a series of codes of ethics for arbitrators, which are still the standard in use today. We have pioneered many and perhaps most of the ethical and fair play standards recognized in the field today. What we're talking about today is a very specific and difficult kind of case, consumer debt collection cases, where creditors are attempting to extract small dollar debt from frequently unrepresented consumers who are often in desperate financial straits. In our discussions with the subcommittee and most recently publicly, we indicated that we do not currently handle nor would we receive these cases at least until some standards are established that are satisfactory. But I'd like to suggest a way forward. About 10 years ago, we established consumer due process protocols to ensure balance in what was then a very young, growing field of arbitration, consumer arbitrations in particular. These protocols, these rules of fair play, were established, as with the earlier Code of Ethics for arbitrators, with individuals from a broad cross-section of society. We had consumer advocates, we had business advocates, we had regulators, we had academics, wide variety of people giving input to what was essentially consensus for some standards for fair play. The consumer due process protocols are today the standard of fair play in the consumer dispute arena, as evidenced by our small consumer caseload outside this debt collection area. We do about 1,100 of those a year. Almost 3/4 of those cases are filed by consumers who are looking for redress. And they win about half of those, and they settle many more of them ahead of time before any decision. The due process protocols do common sense things. They do things like make sure the fees to the consumer are reasonable and that the process is accessible. They declare a right to both parties to have an impartial arbitrator. Very significantly, they provide that all remedies that would be available in court must be available in the arbitration process. And interestingly, there is a feature of the due process protocols where the parties may elect to opt out of the arbitration process and go into small claims court. Strikingly, almost no one elects to do so. Why not? I think the reason is that the consumers in these debt collection cases, and the overwhelming majority of them, don't participate in the process. They are no-shows. It's inevitable that if you don't participate in your legal proceeding, there's a high likelihood you will lose. So this presents an interesting and very important challenge that has not yet been resolved by the courts or in arbitration. How do you construct a special set of due process protocols for these cases so that the rights of the consumer are protected even if they fail to participate? And I think that's the challenge before us. We make some very specific recommendations in our written testimony, specific to these kinds of cases, about notice issues, about arbitrator neutrality, about standards of proof for these cases, whether the parties attend or not. We propose to convene a broad-based, diverse working group to work towards balancing the process in this very specialized area and building protection for the legal rights of parties. This kind of broad community inputting process works, as evidenced by the existing due process protocols, and we would respectfully suggest that Congress should consider making such safeguards universal and mandatory by legislation so that all consumer debt collection arbitrations are properly conducted. Arbitration is a tool. It's simply a tool. It can be adapted to special circumstances to provide for access to fairness and justice for all parties in a dispute. We need to work toward that end, and I have to say it's very doable. We've conducted, for instance, no-fault insurance arbitrations for the Supreme Court and the people of Minnesota for 3 decades now. It's essentially a consumer arbitration process, and it works very well. And I think they present a model for properly conducted consumer arbitrations here. Thank you.
I thank the gentleman. The chair recognizes Mr. Bland for 5 minutes. You may proceed.
Mr. Chairman, thank you so much for the leadership you've shown in this area, both in this hearing and for several years. Going into last week, I think that the entire consumer and civil rights bar of America was just absolutely shocked. Our eyebrows were singed by the unbelievable revelations that came out of General Swanson's case. That filing was amazing to us, that it turned out that this National Arbitration Forum, which had been holding itself out as a neutral and deciding tens of thousands of cases in favor of debt collectors again and again, one after another, was actually largely owned, or owned by 40%, by the debt collectors themselves. But as Michael Kinsley, the pundit, always says, the real scandal is what's already legal. And the scandal here is that for 10 years before General Swanson released these facts, you've had this company operating essentially a rogue system that has been completely tilted in favor of the creditor. First of all, they have this incredible false humility whenever someone challenges them in court, in which they say, well, we're just the court clerks. We don't really make any decisions. That's not true. They picked who the arbitrators are. Who the decision maker are means everything. If I could pick who the judges were in my cases, I would be the legal Michael Jordan sitting here. I'd never lose a case. Who the judges are makes a huge difference. So who did they pick? They say, well, we have 1,500 judges. Now, one thing is they got caught lying in a federal court in West Virginia where they named a bunch of people who were supposedly NAF arbitrators, who were very prominent West Virginia lawyers who weren't. But they do have actually a big roster of a lot of important names. What they do, though, is that they sent cases out to the arbitrators. They figured out who was going to be ruling for the creditor nearly all the time, and they funneled more and more and more of the cases to this small number of people. So out of the 1,500 arbitrators, who decided the 34,000 cases that they publicly reported on in California? Over 90% of those cases were handled by 24 arbitrators. You had one guy who was deciding something like 1,300 cases. You had people who were deciding 68 cases in a day, 40 cases in days, again and again. I mean, that's not judging, that's rubber stamping. They were essentially blackballing anybody who ruled for the consumers, and they were funneling all the cases to people who they knew how they were going to rule. Okay? That is not the same as small claims court. The unbelievable insults in all the small claims court judges of America, you go in and you get who you get by a random selection. Nobody at a corporation sat down and picked which small claims court you got. That's a big difference. A second big difference is that there is no verification or substantiation or evidence required in the National Arbitration Forum before they give the creditor everything that they want. That's an invitation to abuse, and the invitation to abuse has been accepted, particularly by debt buyers. A lot of credit card companies sell the debts, frequently for only a few cents on the dollar, sometimes as little as 0.1 cent on the dollar, to debt buyers, and the debt buyers keep getting further and further away. They usually have no evidence by then. They don't have a copy of a contract, they don't have statements, they don't have anything that actually links. They have a name, and they have an account number, and they have a dollar figure at the end, and that's it. No verification. And what they do is that they frequently then add all kinds of things on. Now, there's the idea here is, well, these people actually owe the debt, right? So since they owe the debt, they deserve to lose. Well, what we've seen again and again, literally in hundreds, if not thousands of cases that we've been able to document, again and again, somebody will owe $1,500 or $1,000 or $2,000, and then a bunch of junk fees are added, interest on interest, which is illegal, attorney's fees, which are not verified. Basically, the attorneys of the debt collector are rubber stamping something, and then they're getting $2,000 in attorney's fees, $1,000 in fees to the National Arbitration Forum, and what becomes a $1,500 debt suddenly becomes a $10,000, even a $15,000 or $20,000 debt. And what happens is that their rubber stamp arbitrators take those, and again and again and again, they just give them 100 cents on what they want. Now, is small claims court that useless and that lousy in America? By and large, it is not. In most courts in America, and there are problems in small claims courts in some places. The Boston Globe story was a great story. By the way, the Boston Globe reporter would be taking my position if he was here. And the idea that Elizabeth Warren would be a fan of the National Arbitration Forum as opposed to small claims court is someone who's never met or spoken to Elizabeth Warren. But what they do is they basically had a deal set up where they would, these debt collectors would send in an email because they have this interconnection where they don't even have to actually file anything. There's no affidavit with it. The only statement is the email says that our client actually gave it to us. They aren't even saying that it's actually true. They're just saying this is truly what our client gave us, and they send in an email with numbers in it. Then the NAF would take the email and they would turn it into the complaint. So the consumer, the thing the consumer gets, isn't even what that was actually filed. All that was filed were some numbers that were taken from a printout. And then the complaint is sent with an order for 100 cents on the dollar. And that order is signed off again and again by the arbitrator. It's a joke. It's not the way small claims court goes. In small claims court, you do get a default. That means you win. As you say, you win. But you don't get 100 cents on what you want. So you can't add on all these junk fees. You can't multiply debts in a crazy way. What's going to happen to all these phony awards? So they've stopped operating as of Friday. But meanwhile, there are hundreds of thousands of people out there, hundreds of thousands of people with phony awards that have been entered in against them. Are those all just going to stand? Or is that okay? And then in the race to the bottom, who's going to replace them? Is the chamber going to be okay with just sitting around and actually having, more neutral arbitrators? Or is the son of the NAF going to appear? Is Mr. Anderson going to run out and open up America's happiest consumer-friendly arbitration company in a week, and that'll replace them? There's no reason why the banks can't do that.
I thank the gentleman for his testimony. Your time has expired. Chair recognizes Professor Drahauser. You may proceed, sir.
Thank you, Mr. Chairman, and Ranking Member Jordan, members of the subcommittee. I'm very pleased to have the opportunity here to talk to you today about at least what colloquially is known as debt collection arbitration. This world has changed dramatically in the last week, as we are all familiar with, and it's been sort of fascinating to be an observer of it. I think my experience in this area is as a scholar, it's not as a participant, and what we've been doing as part of the Searle Civil Justice Institute is looking at consumer arbitrations. The first phase of our study has been to look at AAA consumer arbitrations, not mass claims being filed by creditors, but individual claims, most of which, as Mr. Neymark said, were filed by the consumers, but a number of which were also filed by the creditors. The follow-up phase of that study, I think, is where I can be at least somewhat helpful here to the committee, because it seems to me that one question that we need to think about at this point in the process, given what has happened with consumer arbitration, is where do those claims go now, or what happens in court if those claims end up being decided there instead. And so what we've been doing in the next phase of our study is looking at consumer or businesses bringing debt, or creditors bringing debt collection cases in courts. We've looked at several samples of courts and have at least some preliminary findings to share with the committee. I mean, what that means is it's an ongoing process. We've got more courts we want to look at and more cases we want to look at, but we at least do have some preliminary results. And sort of broadly speaking, those results are as follows. First of all, in the sample of cases we looked at, the creditors win the vast majority of these cases in court. Of all the judgments that we've examined in the courts in our sample, the creditors won 99.7% of the cases, basically all but one in each of the two court samples that we had looked at. Now, compared to that, to our individual American Arbitration Association results, where we found that the business claimants won more like 83% of the cases, won some relief in those cases. I certainly wouldn't suggest that that means that the AAA is better for the consumers. I think a big part of the explanation here is different types of claims. But it's important to have something to compare it to. You can't just look at numbers in one setting and conclude that that means a process is biased or unbiased. Of these judgments being entered in court, virtually all of them were entered by default. 96 to 98% of these cases in court were resolved by default judgments in favor of the creditor. I mean, basically, the consumers just didn't show up. Okay. To the extent we have issues or questions about how you give notice to consumers, what that suggests to me is service of process by a process server is not a magic answer, that even in the court setting, consumers don't show up. And not surprisingly, when they don't show up, they lose. Now, if you compare that to the AAA cases we looked at, again, the individual cases brought by business claimants rather than the mass arbitrations, which we haven't had a chance to look at, under 40% of those cases were resolved without the consumer showing up. So again, this is not a matter of anything inherent in the arbitration process that consumers don't show up. That in fact, they can show up and in some settings do show up if it's in their interest to do so. The third general conclusion that we've reached is in these cases where the creditors are winning, with respect to Mr. Bland, the creditors win 100 cents on the dollar. That essentially they win the entire amount of principal that they seek and the entire amount of interest they are seeking in 97 to 99% of the cases. Right? There's just a handful of cases where the creditor recovers less than the amount that is being sought. Again, if you compare that to our AAA cases, there the creditors won 93%. And again, I'm not suggesting this is necessarily that the consumer arbitration is a superior system. What's going on is these are types of claims where consumers don't show up to dispute them, and when they are resolved by whichever venue, they are resolved almost entirely in the creditor's favor. One final point is in these consumer arbitration, in consumer cases in court, there were no trials. I mean, the vast majority of them were default judgments. There were a few summary judgment motions. None of these things went to jury trial. None of them went to a judge trial. Okay, this is not a matter of these consumers otherwise would be having all these claims adjudicated in court because these cases never make it that far. And again, it's not court versus arbitration, it's just the nature of the claim. So what does that suggest to me? Well, I guess I have two general conclusions. The first is it makes me question whether, in fact, consumers are now going to be better off if they're going to court rather than in arbitration, because the results, I think, at least as far as the outcomes of the cases, look to me pretty much the same at best. And then second, if you think more broadly about the implications for arbitration and evaluating arbitration, what these numbers to me suggest is you cannot find bias in a forum simply because it tends to rule one way. You have to compare it to something. And you have to compare arbitration not to consumer claimants, but you have to compare business claimants in arbitration to business claimants in court. And the claims, the results look an awful lot the same to me. It suggests to me that it's not the venue that matters, it's the type of claim that matters. Thank you.
Thank you, Professor. We are now going to proceed with questioning from members of our subcommittee. And I will start with my 5 minutes and then continue alternating between members of the Democratic members of the panel and the Republican members of the panel. I want to start with Mr. Kelly. Appreciate you being here. Now, in your testimony, you claim that arbitration is fair to consumers. But when you are marketing your services to banks, you tell your service people, and just want to put up a slide here. This is a slide of page 2 from forthright creative paper entitled Non-Mandatory Paper Education. You tell your salespeople to tell the banks that one of the benefits of arbitration is that it gives them control of the process. And in your marketing presentations to collection companies, like the next slide, please. This is the way you describe the effect of arbitration on the consumer. Quote, "The consumer does not know what to expect from arbitration and is more willing to pay." Quote, "They ask you to explain what arbitration is, then basically hand you the money." Quote, "You have all the leverage and the customer really has little choice but to take care of this account." Now, Mr. Kelly, given the arbitrary and unfair results that our staff uncovered in its review of NAF claim files, And given the revelations by Attorney General Swanson in the complaint she filed against the NAF last week of the close financial relationship between the NAF and the debt collection industry, isn't it obvious that consumers have not been getting fair hearings in the NAF arbitrations?
Chairman Kucinich, there were...
Could you speak directly into the mic so everyone can hear you? Thank you.
I'm sorry, yes, sir. There were several questions in there. I'll try to break them down. If I miss one, please.
Start with the fair hearings. Consumers getting fair hearings when the marketing is slanted in that way?
I will say that I'll note that the rest of that presentation does talk about due process protections and also discusses the fact that no outcomes are guaranteed and that the process is neutral, and it does depend on the independence of the specific neutrals. With respect to marketing, we don't shy away from explaining that we do market our services, and we market our services where the largest number of cases are. Frankly, in our civil justice system today, the majority of the cases are debt collection cases, and we market those services. We did, excuse me. I need to keep making that clear. We obviously don't any longer, and won't. But I will say that, you know, at the National Arbitration Forum, they were unabashed believers that arbitration was a superior alternative to court. It is cheaper, it's efficient, it's faster. Now, in the case of collection of debt, it works the same. It would be cheaper, it would be effective, and it would be faster.
Well, you know, but I had some specific questions here. Now, isn't it true that your marketing statements describe the real character of consumer debt collection arbitration? It's intimidating to consumer. It gives much more control and leverage to the creditor, and it leaves the consumer with little choice but to pay. I mean, that's what you've said. Isn't that the true character of consumer debt collection arbitration?
Well, obviously, I can't deny the presence of this document. I believe it was back in 2003. I joined in 2006. I don't believe it's the most artfully drafted presentation by any means. But I will say it's the same. I mean, the process is difficult to work through, whether it's court or whether it's arbitration. We go back to the point that, is it any different between court or arbitration? Is there any fundamental difference? I believe that if there are fundamental differences, they're in favor of arbitration.
Well, you claim that the NAF has rules to protect the consumer, but our investigation finds that NAF doesn't follow those rules. The NAF has a Rule 6 that says that the notice of arbitration must be served promptly. The word promptly is not defined in your Code of Procedure, but until August 1st, 2008, NAF Rule 41B3 said that any claim could be dismissed if more than 90 days passed between the filing of the claim and a proof of service to the notice of arbitration. And that was now the subcommittee staff looked at the forms that the NAF sends to the arbitrator with each batch of claims. They're called desk hearing lists, and each one contains a list of claims that the NAF was assigning in that batch, and it recites for each claim the date on which the claim was filed and the date on which the notice of arbitration was served. These desk hearing lists that we reviewed showed that 160 of 230, approximately 70% of the total, should have been dismissed by the NAF before they were even sent to the arbitrators, because the notice was served more than 90 days, in some cases a lot more than 90 days after filing. But not one of those cases was dismissed. And you know, here is part of the desk hearing list sent to the arbitrator, Snyder. Put up this exhibit, and then I'll move on to the next questioner. It shows that NAF sent arbitrator Snyder claims that were served more than a year after they were filed, clear violations of Rule 6. I mean, this, you know, doesn't it show that you don't really follow your own rules when those rules favor the consumer?
I believe the discussion centers around Rule 41B. What Rule 41B states is a claim or response may be dismissed by an arbitrator or the forum at the request of a party in accord with Rule 18 or on the initiative of the arbitrator. May. May is the key word in this case. The arbitrator has the discretion to make that determination if it's in the interest of justice. That's not for the forum to make. It is for the arbitrator to make, and it is may. It is purely discretionary. Now, I'll have to check this, but my recollection is that this is a fairly new rule as well. So I would have to look at whether this rule was in place.
We're going to move on to Mr. Jordan, and he can have 6.5 minutes to match my time. I just want to say it may be 90 days, it may be a year. It may.
Mr. Kelly, what percentage of your business was debt collection arbitration?
Was it a majority? I don't have a specific number, but yeah, clearly the majority.
And what percentage of overall debt collection arbitration cases around the country did your company handle? Majority?
I couldn't answer that question because I just don't know. Those statistics aren't publicly available, so I don't know what the universe is out there of arbitration. We're a major player, if that's your point.
Were you the largest player? Were you the largest player in this?
I believe I would believe we would be.
And and as of last week, you're no longer in the business.
That's correct.
And we've heard testimony here about the court system, the difficulties there. I mean, maybe this should go to Mr. Neymark or maybe to our Attorney General. But how was now that you're out of the business, you were the biggest player. Are we going to be okay? I mean, Mr. Neymark, you want to comment? Can we handle what's going to happen now?
Well, we have announced that we will not receive these cases, at least at the present time, until there's some establishment of some...
Speak closer to that microphone, please.
Some establishment of additional standards of fair play, like the due process protocols that we described.
So the whole motivation of this hearing is to look out for consumers out there. So what's going to happen in this flux we're in, or this interim period? Would the Attorney General like to comment?
Sure, Mr. Chairman, Ranking Member Jordan. I think that's why it's important for Congress to act. The National Arbitration Forum was as I understand it, the dominant player in the consumer collection industry. There could be other companies, other arbitration companies right now that would take over these claims and could arbitrate them, or a whole new company could pop up tomorrow. And that's why I think this hearing is so important, and commend all of you for your leadership in holding it, and why I think it's important that Congress act to rein in these practices. National Arbitration Forum was one company, but the underlying problems with mandatory pre-dispute arbitrations run across the industry and are systemic.
Attorney General, would you agree with what the professor had to say? I believe his comment was it's not the venue, it's the type of claim that's the determining factor here. Do you think that's an accurate statement?
Ranking Member Jordan, no, I don't. I think the venue is problematic with arbitration because you're essentially allowing the corporations who are litigants to handpick the judge. You're letting the corporations select which arbitration company you want to adjudicate the claim. And based on the interviews we've conducted of consumers, of arbitrators, of employees, there is tremendous pressure on the arbitration companies. It's very, very lucrative and profitable business. And the corporations know that if the arbitration company isn't perceived to be friendly enough to corporate litigants, they can simply move their business to a new company for all the reasons I described. So I think the venue is problematic.
Thank you. Mr. Neymark, what's your response to what the professor, I thought he laid out some good numbers in his statement about the venue versus the type of claim?
Well, I think we see from the research and people's experience that there are similar problems in both court and in arbitration. The real issue is non-participation by the individual debtor. I think it's a real problem. I think somehow or other we need to build in some safeguards. We need to try to get their attention. We need to do better at communicating with them. And I think our civil justice system at large could stand some improvements in terms of due process protections. We could all use it.
Professor, I've been quoting you and haven't given you a chance to talk, so maybe you can elaborate on some of the numbers. I think you talked about the percentages found in favor of the consumer were actually roughly the same, if I remember your numbers. I didn't look at them here closely, in small claims court versus in arbitration. So if you can maybe elaborate on that. I have about a minute left.
Yeah, I mean, the courts we looked at were two. Actually, neither of them was a small claims court. One was claims that the federal government brings in federal court against people who allege to still owe amounts on their student loans. And in those cases, the ones that make it to judgment, the government wins 99.7% of the time. We also looked at a sample of cases from Oklahoma, which has a fabulous online access to their court files for at least a number of the counties that we can actually use for research. I mean, our choice of what we studied, frankly, was totally due to access to the data, and no other factors went into it other than trying to find similar cases. And the courts that we looked at in Oklahoma were actually not the small claims court, but the sort of next up court, which looks at which adjudicates claims of under $10,000. And one difference in Oklahoma is those claims actually, the majority of those claims were brought by debt buyers, so it allows us to look at the results in those cases. And again, of the cases that made it to judgment, 99.7% were resolved in favor of the business, of the creditor in that case. And again, I can't sort of say arbitration is better or worse. I mean, the arbitration cases we looked at were AAA cases, not mass arbitrations, but ones adjudicated in their sort of the typical individual manner. And in those cases, the business won something in about 83% of the cases. And again, I don't tout that to say arbitration is better because consumers win more. What I would say is, it seems to me the reason for those differences is likely differences in the types of claims that are being brought. And I guess one follow-up point is, in going through the AAA's files and doing this research, I mean, we would see correspondence with both sides, businesses, and with consumers who are unhappy. I mean, not surprisingly, when people lose, they're unhappy with the party. And we saw no suggestion whatsoever of kowtowing to business interests or to consumer interests. I mean, the response was the same. We administer these cases, the arbitrators make the decisions, and if you don't like it, you can go somewhere else if you want. But we're going to we're not going to sort of skew the process in one way, one party's favor or the other.
Thank you, Mr. Chairman.
I thank the gentleman. Mr. Cummings is recognized.
Thank you very much, Mr. Chairman. I want to thank all of you for being here. And I just listened here, and I got to tell you, this is a mess. And a lot of the people who are getting ripped off are my constituents. I live in the inner city of Baltimore. And I've listened to this testimony, and I want to thank you, Ms. Swanson, for what you're doing, and others of you who are trying to get to the bottom of this. You know, as I was listening, I've been in those courts. I practice law. I'm a trial lawyer. And, you know, it's one thing for somebody not to show up. And we can do some things probably in our district court systems, our lower court systems, to let people know about the significance of getting certified mail and what it means, and they need to show up. It's another thing to go into a forum thinking that you're going to be treated fair and you're getting screwed. That's a whole nother kind of situation, and I think we need to think about that. And you know, Mr. Kelly, I just want to ask you, you know, the subcommittee staff looked at 230 claims filed by NAF with the NAF by Worldwide Asset Purchasing, and then we got a chart here. In 40 cases, the NAF arbitrator Jennings dismissed the claims because Worldwide did not provide the dates of the last payment or any other information on which Jennings could determine whether the claims were filed within the California statute of limitations. In 18 claims, the NAF arbitrator Kreitinger dismissed the claims because Worldwide did not provide him with any specific information about how the notice of arbitration was served. However, in 172 identical claims that didn't have any more statute of limitations evidence or any more evidence of service than the Jennings and Kreitinger claims had, 3 other arbitrators apparently ignored those deficiencies and issued awards to Worldwide in exactly the amounts requested by Worldwide. Doesn't it show that the results in your debt collection arbitrations depend more on who the arbitrator is than what the facts or the law are? I want to direct that to Mr. Bland.
I think that's exactly right. I think that who the arbitrator is incredibly decisive, and that's why focusing all of the cases on a handful of people mattered. The idea that the data is the same between court and arbitration in front of the NAF is simply not true in several ways. First of all, Congresswoman Watson, when she was here, put the Business Week article in the record. Business Week discovered that debt buyers are willing to pay like twice as much money for old debts, particularly debts that are outside of the statute of limitations, if there was a National Arbitration Forum clause on it. The debt buyer industry, they think it's worth a lot more money to have an old debt or a debt that's not good in front of the NAF than they did in small claims court. The idea that you compare these types of really old debts in credit card context with student loans is totally off the wall, to be honest, because student loans have no statute of limitations. You can be pursued on a student loan that you took out 70 years ago. The Supreme Court and Congress, because Congress wants student loans to be collected, has a totally different set of rules than debt collections. Also, I mean, the advertisements of the organization, they particularly wrote advertisements aimed at debt collectors that would say, we will improve your bottom line, was one advertisement, or 66% better results was another advertisement we've seen.
Mr. Bland, thank you. Now I want to hear from Mr. Kelly, if you don't mind.
On what was the specific question, Mr. Cummins?
You don't want me to repeat that long question.
Well, do you want me to talk about this, or do you want me to address Mr. Bland's comments?
I want you to, yes, you can go ahead and address this statement and the question.
First of all, once the cases are given to the arbitrators are the finding of fact. Now, I'm not a trial lawyer, but as a corporate finance lawyer, I can tell you I've gone with clients to court in certain venues in certain jurisdictions and been crushed by judges on the same point of law that in other jurisdictions in front of other justices we've prevailed on.
Can you arbitrate or shop?
Can you arbitrate or shop?
Yeah.
Will the gentleman yield?
Yes, of course.
Is that why you go ahead and try to get the arbitrators who are going to give you a better decision?
Which is where I was going, Mr. Chairman.
Yeah. Would you like me to talk about how the arbitrators are actually assigned?
Yeah, and I asked you, is it possible to arbitrate or shop? In other words, just like you shop for a judge?
There is a strike rule in the National Arbitration Forum rules, similar to the strike rule in many courts. The state of Minnesota, which is where the forum was founded, has a strike rule, where each party, for any reason, can strike the arbitrator once. Now, the rules also provide that the parties can agree on an arbitrator as well. So that's the process that's employed.
Gentleman's time has expired.
Thank you.
Chair recognizes Mr. Schock. You may proceed.
Thank you, Mr. Chairman. Thank you all for your testimony here today. I guess I'm interested specifically in where we go from here. Obviously, there seems to be some issues that were brought forward by Attorney General Swanson. I'm sure some of these problems were not just specific to Minnesota. I live in Illinois. I'm sure the other 48 states have similar problems. That being said, I'm not sure that I'm ready to throw away the arbitration process. I'm not convinced that all consumers would be better off going to the court of law, having to hire an attorney, having to incur those costs for what would otherwise be a small claims court item. So I guess if you could enlighten us through your work, Attorney General Swanson, on where you think the Congress ought to be looking to improve the arbitration process, unless in fact you believe we should do away with the process altogether.
Sure. Thank you, Congressman. You know, the biggest problem I see from all of the interviews and discussions we've had is, again, this ability of the corporation who writes the clause into the contract to handpick the arbitration company who's going to adjudicate the claims. It's not how it works in court. In court, you know, you file a lawsuit, you get the judge, and that's the judge of the case, and that judge is not dependent upon that corporation for the salary. The salary comes from the taxpayers. I can speak to Minnesota. In Minnesota, we've got good small claims court. If you go into small claims court in Minnesota, the judges, even if the consumer doesn't show up in a default hearing, they tend to scrutinize those cases. You know, does the consumer appear to owe the money? Did they actually incur the debt? Are the T's crossed and the I's dotted such that before that judge issues a default judgment that that it looks like there's sufficient evidence to enter that judgment? I think the problem is that, for example, when you look at these consumer due process protocols that have been discussed, NAF largely followed them too, or had them supposedly, but yet it didn't stop a whole lot of consumers in Illinois. We've talked to Illinois people in Ohio and around the whole country from getting hurt. And so I think what Congress ought to do is say that in these kinds of situations where the consumer has no leverage, where the company is giving them contracts on a take-it-or-leave-it basis, the consumer is not seeing the clause, that they ought not to be allowed in the area of the credit card disputes, consumer disputes, cell phone contracts, that mandatory pre-dispute arbitration clauses shouldn't be allowed.
So what should happen if I'm a consumer and I refuse to pay my $100 bill, which now becomes $150 or what have you? You can fast forward down the line. What should happen?
Well, a couple things could happen. One could be, after the fact, the consumer could agree to arbitration. If pre-dispute arbitration clauses weren't allowed and the collection agency is pursuing the consumer to pay that bill, and if they actually owe the bill, they could agree after the fact to arbitrate in a mutually a forum that's mutually in both parties' best interest. The creditor could file a claim in small claims court, which at least in Minnesota, is straightforward, moves quickly. People do have a right of appeal to a district court there. Those are a couple ways. And then certainly the creditor has all of their other collection opportunities available, reporting to credit bureaus, et cetera.
Mm-hmm. Okay. Well, I find it interesting that even the federal government uses an arbitration process when we choose to collect our debts, specifically student loans, in which arbitrators rule on behalf of the federal government nearly 99% of the time. I guess, Mr. Neymark, if you could speak to the claims that the arbitration organizations are unduly biased towards business, would you like to respond to that?
Sure. Let me approach it this way. I think the key issue here is the arbitrator, who's the decision maker in the case. And you can do a number of things, which we do, to enhance the trust in the neutrality of the arbitrator. First of all, a thorough review of the people who are put on the panel or the list of potential arbitrators, so that you're sure you have people of the right kinds of background and history. We follow a very strict disclosure process where any contact or issue that might be disclosable has to be disclosed to the parties, giving them an opportunity to object. Thorough training for the arbitrators, and I would suggest in the debt collection area that training needs to be beefed up to deal with some of the specific issues we're talking about today in terms of due process protection and the kinds of interest decisions and others, so that you're sure that the arbitrators are familiar with those things. We did one other thing for the short time we administered some of these cases, and we had an internal operating process where we said if the consumer showed up and made an objection to an arbitrator, it was an automatic removal. And if the business objected, we would not remove them. And that way you don't get to stack the entire pool of arbitrators.
Say that again. If a consumer objected to the arbitrator, in other words, the consumer...
Gentleman's time's expired. But
okay.
Why don't you answer what he said?
Yeah, if the consumer objected, we'd remove the arbitrator. If the business objected, we would not. So
and I don't mean to extend your lease, but how would they object? They just say, I think this arbitrator is biased. They have to fill out a form. What's involved with that?
Gentleman's time's expired. You may be new to this committee, but I try to allow everybody plenty of time here, and we're going to go to Mr. Foster. We'll come back for another round.
Thank you.
Yeah, I serve on the Financial Services Committee, and we're in the process of marking up legislation on the Obama proposal. And I guess the relevant part for this discussion here is the proposal for a Consumer Financial Protection Agency. And I was wondering if any of you could comment on... Do more. If any of you could comment on, first off, whether the proposed grant of authority under this proposal would be sufficient to deal with this problem, frankly, and secondly, whether the suggestion of a federal preemption as opposed to a federal floor, with the states allowed to raise the bar for a higher level of protection, would be more appropriate for this level of situation. Anyone who wants to pick that up? Yes, Attorney General.
Well, certainly representing the state of Minnesota, and I think my colleagues in other states would agree that we would be certainly I would be strongly opposed to any type of federal preemption of states' ability to do better to protect their citizens, their consumers. I think our country right now is facing an economic meltdown that had we had more cops on the beat, perhaps we would have been better served. And so I think if Congress or if the federal government can pass a floor to protect consumers, I think that's a good thing. I think it's healthy to have multiple regulators on a beat because hopefully if one's not acting, the other will. But in terms of preempting states' ability to act, I think that would be misguided. And as you know, we're seeing a trend away from that with the recent Supreme Court ruling of the U.S. Supreme Court allowing states to move more toward being able to enforce laws. I think that's a good thing.
Now, is the grant of authority, are you familiar enough with it to see holes in the grant of authority? Or would that have been sufficient to at least have the CFPA in principle act on this thing? On
you know, Congressman, I'm not familiar enough with the actual language.
Yeah, Mr. Bland?
Congressman, I think that with respect to financial services, that the grant of authority that's in the statute, in the proposed statute or proposed legislation, would be enough to solve the problems of abuse of mandatory arbitration. I think it would let the federal government come in and ban these clauses where they're being abused by payday lenders and subprime lenders and a variety of other ways. And I think the language is broad enough. Where it doesn't address is issues such as civil rights. I mean, there's a lot of employment cases that are being sent to arbitration where you end up with an arbitrator who's defends companies against civil rights claims being the judge, and there's a lot of other areas like that it doesn't address. But for financial services, the language I think is very broad and would deal with the problem very well. And with respect to the preemption issue, I think one of the things you'd see if you read through some of the briefing in the most recent Cuomo versus Clearinghouse case was that state regulators bring tons of cases against banks for deceptive practices, for racial discrimination in lending and so forth. And the federal agencies, the OCC, the Office of Comptroller of Currency, and the OTS, have done almost nothing. And what happened in the last 8 years was you had the last administration dramatically change and rewrite the regulations so as to basically give banks a sort of a get-out-of-jail-free card and wipe away state laws that state regulators used to enforce really vigorously. So having the states have it be a floor rather than a ceiling would be a dramatic and really valuable change.
Yeah. Do any the other of you have comments about what's good, bad, and ugly about these proposals? No. Okay. Well, I yield back in that case.
I thank the gentleman. Chair recognizes gentleman from Georgia. Johnson.
Thank you, Mr. Chairman, for holding this very timely hearing and allowing me to be a part of it. I do appreciate it, and I will say that H.R. 1020, which is a bill to ban pre-dispute mandatory arbitration clauses in consumer agreements, in employment agreements, and in franchisee agreements, would be the ultimate fix of this problem. And the problem is that we're trying to outsource or privatize these kinds of resolutions, if you will, by sidestepping the civil process, the courthouse, in other words. And when I got this vision in my mind of the courthouse on the square, and there's you can go around the courthouse in a circle, and then there's all these restaurants with great breakfasts and great lunches, and you can be there all day. And I'm thinking about a hot summer day with the fan just kind of twirling around lazily. It's a lazy afternoon, and nothing else to do. I've hung out on the porch since early morning, did a little fishing. After that, played some checkers. Thereafter, got something to eat at lunchtime, and now I heard about this great lawyer that's trying this case over here in the courthouse. I'll go over there, and you spend your afternoons watching the lawyers, and at that same courthouse, you can, if you want to know whether or not your neighbor has beaten his wife, how many times that he has beat his wife, you can go to the courthouse and find that. If you need to look at the adoption papers, you just adopted a child, you can find that at the courthouse. Your real estate deeds, your liens, how many people have sued you, how many convictions do you have? All of that information is at the courthouse. And at the courthouse, you can't lie. You cannot lie because you get charged with perjury or obstruction. And it's okay to lie to your neighbor across the fence, telling them about that big fish that you caught, or that hole in one that you hit. You know, you can lie about things like that, but you can't lie in the courthouse. Now, arbitration is different. There's no place for a trial, a public trial, where people can come and enjoy the proceedings. There are no public records to be viewed. In fact, most folks don't even, the public doesn't even know when there's an arbitration proceeding taking place. And then when the arbitrator rules, and he or she even goes against the National Arbitration Forum rules, which are advisory in my opinion only, not binding in any way, then you have no meaningful right to appeal the decision. And so the only thing that I can see that we need to do is what I've done with my Arbitration Fairness Act of 2008, and again in the 111th Congress, the H.R. 1020. And I'm proud to announce that there are a number of members of this committee, including the chairman, who have signed on as co-sponsors. I know Mr. Cummings is on that bill also, and that's the best way to solve this problem, is that the Sixth Amendment right to a civil trial in any endeavor, any dispute in excess of $20 needs to be adhered to.
The gentleman's time has expired. Although I will say the gentleman and all the other members are welcome to return in 1 hour. Committee will come to order. Thank you for waiting. The vagaries of business on Capitol Hill is that we are always subject to the activities on the floor of the House. And so we just completed business for the day. I note that Attorney General Swanson is going to have to leave at 5, so you'll be permitted to leave at 5 p.m. in order to accommodate your flight back to Minnesota. And at 5 o'clock, you may leave. That's, you know, we're grateful for your presence here, and the committee will be in touch with you regarding this matter. Appreciate that you're here. Thank you, Madam Attorney General. Thank you. Mr. Kelly, you're required by California statute, California Code of Civil Procedure, Section 1281.96, to publish the results of all your California consumer arbitrations. but the subcommittee's investigation reveals that you don't publish the results of all of your California arbitrations involving consumers. You only publish the results of some of them. For example, you administered 2,331 California arbitrations filed against consumers by Columbia Credit Services, but you haven't published the results of any of those arbitrations. The explanation your representative gave our staff is that while California requires reporting of consumer arbitrations, it does not define the term consumer arbitrations. Mr. Kelly, tell me, is there any way at all in which an arbitration filed by Columbia to collect on a consumer debt assigned by MBNA Bank is any less a consumer arbitration than an arbitration filed by Worldwide Asset Purchasing to collect on a consumer debt assigned by MBNA Bank?
Chairman Kucinich, the circumstances you're describing is accurate. There is no definition in the statute. So you take a very hazardous course if you make a determination one way or another. What we did in that circumstance is we relied on the filers to indicate what's a consumer case and what's not a consumer case. We didn't make an independent judgment, review the facts of the case, and frankly, that in and of itself could argue against the neutrality of the process. So we left it alone. If the filers designated as consumer, it was designated as a consumer. I will point out that even some of our most vocal opponents have indicated on the record that our filing in California is far superior and far more complete to many of the other providers of neutral services. And we can provide that specific reference if you so choose.
Well, I have to say respectfully that what you're saying defies credibility, because contrary to your representative's explanations to us, in fact, Mr. Kelly, California does define the term consumer arbitrations. This is a quote from Section 2, the definitions section of the California Ethics Standards for Neutral Arbitrators in Contractual Arbitration. I'm going to put up the document. It's a pretty quick read, but what they do is they basically define consumer arbitration, and it's a pretty succinct definition. Now, isn't it really true that all of the Columbia claims are consumer arbitrations?
Mr. Chairman,
that's under the California Act.
I have to admit I'm not intimately familiar with the California law and the statutes there. Thankfully, the representative who you're referring to is here today. If you might give me a moment.
I'm sorry, that what?
The representative of our organization that you're referring to is here today.
Do you want to confer with somebody?
Yes, if I may.
We're giving him a copy. We're going to give you, what we're going to do, I'm going to ask staff to provide you with a definition of of consumer arbitration. I'd like you to look at it a moment. And we'll wait.
Yes, sir. Thank you.
Just take your time.
Mr. Chairman, if I may.
Yeah, the gentleman may proceed. I started off by asking you a question so we can frame this properly. What I said is that contrary to your representative's explanation to us, California does define the term consumer arbitration. We've just given you a copy of the definition. And I began to quote from Section 2, but since you've read it, I don't need to do that. And without objection, Section 2 is going to be included in the record of this hearing. Now, again, Mr. Kelly, isn't it true that all of the Columbia claims are consumer arbitrations under this California definition?
Under this definition, I couldn't tell you. This is the first time I've seen this definition.
Well, let me just say,
this
the
definition,
contract,
Mr. Chairman, is not the definition at issue.
Bear with me on this. The contract is with a consumer party as defined in the standards. Isn't that right? Isn't it right?
I'm not following you, Mr. Chairman. I'm sorry.
The contract that we're talking about here is with a consumer party, right?
Which contract are you referring to?
These are consumer arbitrations, the contracts with a consumer party, right?
I haven't looked at these specific
cases. In the Columbia
cases.
case, are you familiar with the Columbia case?
I'm aware.
The Columbia cases. You're familiar with the Columbia cases?
I'm aware that Columbia cases are at issue in the San Francisco lawsuit.
So we're going back to the definition of consumer arbitration in California, which is where we're focused here. The contract is with a consumer party in the Columbia case. The contract in which the debt is incurred is with a consumer party, correct?
I would disagree if what you're talking about is the reporting statute. The definition that you've presented here is not a definition in this statute. I mean, it is inappropriate to take a random definition of consumer in some unrelated statute.
This is right from the California ethics standards for neutral arbitrators and contractual arbitration.
But it is
now,
not.
You can't, you can argue with me. You can't argue with those words. This is right from that. We didn't make that up.
I'm not saying that, and I completely agree with you on that
point. Are you currently being prosecuted for violations of this statute?
We are in suit in San Francisco, yes.
So I think it's clear that NAF is violating California law, but why?
Well, that's at issue in the lawsuit, and we would strongly disagree with it. And I'm not sure I'm making my point clear,
well,
but this is not the reporting statute
The
at issue in
subcommittee
the San
staff
Francisco
obtained the
case.
case files of 48 NAF arbitrations filed by Columbia. And those files show that Columbia routinely asked arbitrators to add attorney's fees of 33%, despite the fact that the controlling Delaware statute places an upper limit of 20% on attorney's fees. In most of these cases, Columbia received attorney's fees that violated Delaware law. Now, isn't it true that your failure to publish the results of your Columbia arbitrations in California assists Columbia in concealing its violation of Delaware law?
Chairman Kucinich, we can certainly provide you the information necessary to respond to that. I can't tell you here today what the facts are or what the arbitrators decided in those cases. Frankly, that's a matter of law, and not an issue that I'm prepared to qualify here one way or another.
Well, we're going to take your explanation. We're going to move on. Columbia is not, but I think that since we have other members of the committee who have not been able to come back for this second round, the committee is going to submit this question in writing and give you the opportunity to answer succinctly and with some detail in writing. So we can, I want to move to that, make sure we send a letter to Mr.
We would
Kelly.
appreciate that, Mr. Chairman. I apologize for the confusion.
Well, we're not confused about this. Columbia is not the only collection company whose California arbitration results you do not publish in violation of California law. Your representative informed our staff that there are others. Do you know whether or not those other collection companies are also asking for and obtaining awards of attorney fees that violate Delaware laws?
As we sit here, Mr. Chairman, I don't have personal knowledge
We're
of that.
going to send you a written request, and we're going to ask you to provide the committee with a list of companies whose California cases you have not published. And we appreciate your cooperation with this subcommittee.
You'll have the cooperation.
Yeah, because I just, you know, we just had that discussion. Now, Mr. Kelly, let's look at, for a minute, I want to look at one reason why consumers, we're going to, you know, I'm waiting for anybody from your side who wants to come. I'll be glad to yield to them. I'm going to go to a third round now. Mr. Kelly, let's look for a minute at one reason why consumers may not have appeared at one of your consumer arbitrations. In all of the claim files that the NAF produced to our subcommittee staff, the only evidence that the consumer knew about the arbitration was a form statement by the creditor's attorney that the respondent was, quote, served with the initial documents required by Rule 6, unquote, and that, quote, service conforms to the requirements of Rule 6 and applicable law, unquote. There is no evidence of who actually performed the service, who was served, or the documents were served. Now, in each and every one of these cases, the NAF has absolutely no idea who actually received the service. Isn't that right?
In response to that, I will say that our rules provide for service in a number of manners, and the rule is pretty clear on this. Certified mail can be delivered personally. Proof of that service must be provided in order for the case to proceed. The rules are consistent with those, as I understand it, in the Federal Rules of Civil Procedure. I will note that in most small claims court, all that needs to be done is regular mail.
Well,
our procedures
you need
are
an
far more
affidavit,
involved than that.
but isn't it true that there's no return receipt showing the signature of who actually received the documents? Isn't that right?
I would disagree with that.
There's a return receipt?
In the cases, I certainly can't speak for every case in the system, but by and large, we get, if there's certified mail, we by and large do get a return receipt, as far as I know. Now, obviously, we'd need to go back and we need to look at the specific cases you're referring to, because I'm not familiar with those specific cases.
Am I correct that it's NAF's position that the adequacy of service is an issue for the arbitrator and the arbitrator alone to decide?
That is correct.
Well, I want to see how this works in context. I'm going to ask staff to hand to Mr. Kelly a complaint by Mr. Benjamin Guzman, who was a respondent in an arbitration handled by the NAF. He states that he never received any notice of arbitration and that the person alleged to have received the notice was his landlord, for whom Mr. Guzman was not on speaking terms at the time. The NAF's official response, written by your staff counsel, Mr. Ryan Chandley, was that the creditor filing the claim required a proof of service and that, quote, the decision about the adequacy of service, in this case, would be decided by the arbitrator hearing the case. I just want to, I want you to walk through this with me. Got the creditor filing the claim, serves Mr. Guzman's landlord, files a proof of service saying that the creditor served Mr. Guzman. Mr. Guzman, no notice of the claim because his landlord didn't tell him about it. Mr. Guzman does not appear at the hearing because he doesn't know about it. The arbitrator didn't know that Mr. Guzman was not served because the proof of service says Mr. Guzman was served. So, Mr. Kelly, how can the arbitrator make a decision about adequacy of service? He or she can't. Can they? They don't have any time, they don't have any true information. The only information an arbitrator has is that Mr. Guzman actually was served. So when the NAF responds that, quote, the decision about the adequacy of service would be decided by the arbitrator hearing the case, can you see how that would seem disingenuous?
Mr. Chairman, if Mr. Guzman was not properly served, that is a defense that he can raise in the arbitration, and a defense that he should raise with the arbitrator. That is a matter of law.
How does he? Okay, let's stop right there. You know, these hearings don't have to be that formal. He doesn't know. Get it? He doesn't even know about it. Went to his landlord. Isn't talking to him.
So run the string.
So how do you assert your rights if you don't even know that you were cast into some proceeding?
So let's run the string out then.
Help me with this. I'm interested.
Eventually, presumably, now, Mr. Shanley's here, and I can ask him about the specific case. But let's just run the logical string out on that. So Mr. Guzman doesn't know that he's been sued, right?
Okay.
Which, by the way, the Boston Globe talks about routinely in small claims and conciliation court, because there only mail is required, not certified mail.
We're talking arbitration, NAF.
So let me get that. So then Mr. Guzman at some point presumably learns the judgment has been entered against him, correct?
How'd that happen?
I assume that I don't know, but I'm speaking of a hypothetical now because I'm this specific case, Mr.
So you're saying at some point he's going to find out a judgment was entered against him, but the judgment occurs, one would assume, principally because he wasn't even in court in this arbitration setting to defend himself.
His opportunities are to reopen the case, to move to vacate the award, to move to amend.
How often does that happen?
He also has an opportunity at the court hearing in district court when that arbitration award is going to be enforced to at that point move to set aside the arbitration.
Does that happen very often? And if people don't know enough to negotiate an arbitration, how are they going to know or have the resources to negotiate a court appeal?
Well, it isn't a court appeal. All it is a hearing to confirm the arbitration award. But I mean, then you get into your fundamental policy issue, Mr. Chairman.
Well, let me ask you. You were talking about, you know, what he can do.
Mm-hmm.
How much time does Mr. Guzman have to set this decision aside?
I need to consult on that, if I may.
How much? Yeah, go ahead. Sure. I yield myself such time as I may consume here.
I'm sorry, what was that?
No, I was just committee formalities saying we're going to continue. Go ahead.
Mr. Chairman, I reiterate that I don't claim to be an expert in this area of law. I'm advised by the staff counsel that you spoke with that the time is generally 90 days, but there are exceptional circumstances which can be considered under the rules.
And if the creditor doesn't file within 90 days and waits, what happens then to Mr. Guzman?
Then it would fall under those exceptional circumstances I previously mentioned.
Mr. Bland, would you like to comment on this?
There's actually, it's a distressing thing about our court system right now, but there's actually a circuit split, as I understand it, among the different federal circuits and also among the state courts about what happens if the arbitration award's entered and the consumer has 90 days under the Federal Arbitration Act and under the vast majority of the state arbitration acts. If they don't move to vacate the judgment within the 90 days, for example, because they don't know about it, there are a number of courts which have actually said that they can't then come in and challenge any aspect of the award, even in service. I mean, there's some courts that have this terrible catch-22. Now, there are more courts sort of on the consumer side of this, but that actually has happened a number of times in courts in America where even identity theft victims who can prove that it was never their credit card or whatever have a arbitration award entered against them, don't find out about it till after the 90 days, and then when there's a confirmation proceeding, they can't defend. I mean, it differs from court to court, but there are a lot of courts they can't
try to
defend.
help answer the question that I asked Mr. Kelly. What happens after 90 days?
It depends on what part of the country you're in, but in a lot of parts of the country, you're nailed down and stuck with it, even if you've never got notice. I mean, it depends. There are parts of the country where you can defend against the confirmation in court if you've got a lawyer, but there are actually a lot of parts of the country where that sticks. It's incredibly unfair.
You heard me lay out the case of Mr. Benjamin Guzman.
Yes, sir.
How many Benjamin Guzmans are out there, do you think?
Well, there are tons. In my testimony at pages 18 to 20, we set out a whole bunch of examples of instances where there are terrible service of process, and then we gave you a list of 9 or 10 consumer lawyers who, not just us, I'm not the only person in the world who says that there are a whole bunch of people who have come into my office and said, I never got service. I did a case in the NAF that was a nursing home collections case where our client was in her 90s and she had Alzheimer's, and they served the house of one of her daughters where she had lived like 4 addresses before. I mean, it was incredibly ridiculous service, and then they enter a award of $20,000.
Do you have any idea of how many people
Thousands.
have had
Thousands.
arbitration awards issued against them without ever receiving notice the arbitration was going to occur?
It's going to be in the thousands. I mean, it would be impossible to give you an exact number, but it's going to be.
Mr. Kelly, do you have a response to that? Is that possible, that there could be thousands of people out there who have arbitration awards issued against them without ever receiving notice that an arbitration was going to occur?
I couldn't begin to answer that.
Okay. I want to ask you, Mr. Kelly, about the relationship with the accretive alleged in Minnesota's Attorney General's suit. And, I just, hold on a minute. Yeah, I know you've settled this case, but if I'm asking any questions that may bring some new things and you're not sure, you do have a right not to testify. You'd have to assert it. You knew at or about the time of the reorganization of the NAF, in which the Agora funds set up by accretive acquired a 40% ownership interest in your company, that accretive was acquiring or had acquired the 3 largest U.S. debt collection firms, speaking of Mann-Bracken, Wolpoff and Abramson, and Escanos and Adler. And you knew that that relationship had to be concealed in order to maintain the appearance that the NAF was an impartial body with no ties to the debt collection industry. I want to show you a slide in which you clearly state your intent to conceal the true nature of your financial relationships. Put that slide up, okay? Do you got a staff? And we're going to give you a copy so you know exactly what we're talking about. Is this it right here? Where is it? Yeah, this is a memo from you to Madhu Tedikonda, dated Monday, November 20th, 2006. And the relevant part of this memo, Madhu, I look forward to working with you too. And then you go on to say, we remain deeply concerned about walling any deal off, any deal, from Mann-Bracken. The shared ownership issue concerns us on many levels. Go on to say in enumerated paragraph number 3 that, in parentheses, no public information concerning accretive with the fund that ultimately acquires and holds a minority interest in the forum. And then in a later paragraph, you state, I cannot overstate our concern over the Mann-Bracken relationship, although I do not have any solutions off the top of my head. And this is highlighted. We should certainly plan for unwinding any deal in the event shared ownership becomes an acute issue. Now, if the public knew about the true nature of NAF's financial relationships to the largest debt collection companies in the country, do you think anyone would believe that the NAF was fair or independent or uncompromised?
Well, let's be very clear about the structure here, because I think there's some things in there that can be grossly misleading. Let me just say this.
We'll clarify.
This is accurate. I will clarify. This is obviously accurate, and I did have these concerns. So then I say in here, I want to put some additional thinking around the structural issues. So we did. I want to point out that there is no ownership.
It's not, but you're saying you did, but that's not really reflected in this memo, is it?
No, because there are subsequent. Obviously, this was one of the very first memos in our transactional discussions.
So as we go through this, you're saying that you have other documentation you could provide to this committee that you were trying to get to what point?
We can certainly provide more information, but I can walk you through what was done. It's actually, there's nothing particularly unusual or sinister about it. The first point is that the ownership of the National Arbitration Forum never changed. There's no corporate ownership in the National Arbitration Forum. The same individuals own that entity that always owned that entity. Some of the assets of the National Arbitration Forum were conveyed to an entity, Forthright, which I'm now the CEO of. Forthright, not the National Arbitration Forum, did accept outside investors, a minority. So the first point that's important to note
were they
is
involved
it's a minority.
Were they involved in debt collection?
Well, let's qualify that. So that 40%, was then sold to approximately 17. There are approximately 17 funds, not one, 17 that were part of Agora, roughly 17. We can find you the specific number and provide that.
Were you involved in helping to put this deal together?
Excuse me. Of those 17, one fund was accretive. All right? So 1/17 of those funds was accretive that held a minority interest of 40% in an entity that was not the National Arbitration Forum, but that serviced the National Arbitration Forum.
Well, how did you end up with, how did you end up with accretive then if 16 out of 17 was not involved, then how did accretive come in and how did they just so happen to be a debt collection company?
Well, no, all those funds participated. Agora includes roughly 17 diverse funds, which include the endowment funds of 4 major universities, for example. We can provide you with that information. But accretive is just one of those 17 funds in the 40%.
It's just coincidence that you had a partnership here with a debt collection company?
No, there was no partnership with a debt collection. Accretive, which is one of the 17 funds that bought 40% of the servicing company, also has an investment in a company
Did you know that?
services.
Was that a surprise to you that they were involved in debt collection?
We were aware. I'm not sure we were aware at the time. I believe we were aware at the time that they had an investment. Which,
well, you must have
keep
known
in mind,
something.
in private equity, it is not uncommon for private equity funds to have hundreds, in fact, thousands of
I understand that, but you know what's
companies.
interesting about this memo is that, well, you could have mentioned hundreds of different entities. You mentioned Man Bracken.
Well, this is the one. The other ones didn't cause any concern. This was the one that caused concern, and we went to great lengths to protect and build in.
So you're saying you made every effort not to have any relationship with debt collection companies. Is that your testimony?
I would say that's right. I would say that we did a lot of structural things in order to create Chinese walls and wall off that small fund from the entity, including after we did the split. We had a whole segregation team together which weighed all the practices, separated everything from databases and phone lines, went through it. I did not sit on that segregation.
How do you explain this memo, though? Help me.
We had the largest law firm in Minneapolis review and do a full legal audit on the process.
But you're here right now, and I've got your memo, and I've got your words.
Correct.
And I see you mentioned Man Bracken, which was was about to be acquired by Accretive, big debt collection firm. You mentioned in your memo that you were concerned about walling any deal from Man Bracken. Okay, we know what that means. Then you mentioned you cannot overstate your concern about the Man Bracken relationship, and that you say that, in parentheses, no public information connecting Accretive with the fund that ultimately acquires and holds a minority interest in the forum. Now, if you know, and anybody who reads that, if it's a fair reading, that you were just trying to keep this a secret. I mean, what was going on in your mind? Why were you afraid of that?
Actually, for competitive reasons, frankly, my concern was that we would have a difficult time marketing to other businesses and other entities. That was my concern.
Play this out. Why?
Because there was this particular investment, which is why we protected against it fully. To ensure that when we do make it public, we're able to say we have these protections in place and this is why it's fair, which is in fact what we did.
What happens to the $42 million?
In fact, it was public before this. I mean, we were required to make these disclosures in a number of states. This is not something that is, frankly, we didn't think that there was an issue with it, to be honest, and we still don't.
Well, then what happens to the $42 million that the Agora funds invested in Forthright and the NAF? What happens to that money?
The money that's invested in Agora? The money Agora invested into Forthright?
That the Agora funds invested in Forthright. What happens to that? Well, they invested in Forthright and the NAF. What happens to the $42 million?
Are you asking where that $42 million is?
What happens to it?
The $42 million, by and large, was distributed to the shareholders.
$42 million distributed to the shareholders. Who are the shareholders?
The shareholders of Forthright include NAF Inc., the Agora funds, and there's a management pool in there as well.
And are there any other shareholder interests there that we're talking about that you're aware of?
Not that I'm aware, but that we can provide that information to you.
That you can provide, I would like you to provide to the committee all the shareholders receiving any of the distribution.
We'd be happy to do that. The information was freely provided to the Attorney General as well. Be happy to provide that.
Okay. Now, in Ms. Swanson's testimony, it was stated that the Small Business Administration was instrumental in the creation of the arbitration debt collection conglomerate that she brought charges against and stymied her investigation into the NAF. Just, if you could help me here, Mr. Kelly, can you think of any legitimate justification for using money from the Small Business Administration to finance the creation of Axient, which joined together the three largest debt collection companies in the United States?
Mr. Chairman, I can't answer that question because I have no. You have to answer that question would have to be answered by Axient or someone else. I can tell you that the SBA is not a participant in the Agora Fund. There is no SBA money in the Agora Fund.
Did you have any communications with any representatives of the SBA in connection with their response to the investigation of the Minnesota Attorney General?
I in fact, have never had any interaction that I'm aware of with the SBA, and neither has anyone from Forthright.
Anybody in your company that was directed to have contact with the SBA? No. If you didn't? Do you know anybody in your company who has?
No, and again, as I said, I wouldn't imagine there ever would be, because the SBA is not invested in Agora.
Has anyone in NAF Inc. had any contact with the SBA?
No, there's no investment. There's no investment by the SBA there. I think I can just clarify this. I mean, I don't mean to be confrontational. I don't intend to be. We're out of the business.
Can I tell you, I'm not a confrontational person.
But I will say, I think that you may misunderstand the SBA investment. Trust me, I hesitate to speak for the Attorney General, but as I understand it, the SBA investment is in a fund other than Agora. It's in another investment. That investment is, as far as I know, unrelated to.
Unconnected to Axient in any way?
It may be, but that's the question I can't answer.
So you're saying, as far as the structure of it, you're not familiar?
Yeah, it's not in our structure.
But that you never had any connection with or meetings with any representatives of the SBA, and no one connected with you in any of your capacities had any communication with the SBA about the investigative matter at the Minnesota Attorney General's office?
That is correct, sir.
I think that we've covered most of the territory that we can cover today. We've had a number of witnesses here sit here while Mr. Kelly's had to do most of the work. Is there anything you'd like to say in conclusion? You want to make any final statements before we wrap this up? Professor, do you want to say anything?
I mean, I don't think I have anything to add from my opening statement, which is, I mean, the most important thing to me, it seems to me, is if we're evaluating arbitration as a process, we can't do it in isolation, that we need to compare it to the alternatives. And I sort of urge the committee to keep that and sort of take that into account.
Thank you. Mr. Bland?
Congressman, I think you've got the big picture here totally. If I could make one suggestion with respect to the California disclosure issues, I think that from the cases that have come into us and complaints we've gotten from California consumers and from contacts we've gotten from a bunch of California lawyers, that the disclosures that have been made leave out, apparently on purpose, two really important things. California was trying to figure out not just who won the case and how many cases were brought by certain companies, but they were trying to figure out if the arbitration fees were big in particular cases. And they were trying to figure out, secondly, whether there was a lot of attorney's fees being added in, because there are limits under the debt collection laws about the amount of attorney's fees that can be added in. And what's happened in a bunch of cases that we've seen from consumers and other California consumer lawyers have seen is that a company, a debt collector, will bring a claim, say, for $5,000. Then they have a $1,000 claim for attorney's fees and a $1,000 claim for arbitration fees. And what gets and they get it all from the arbitrator. And what shows up on the internet in their disclosures is claim of $7,000, award $7,000, attorney's fees 0, arbitration fees 0. And so it gets bundled in so that the answer a consumer gets, they get the impression that there's no arbitration fees, they get the impression that there's no attorney's fees, and that's the whole point of the statute asking the question, is to get an honest answer to that. And I think that if the committee is going to ask some written questions, I urge you to probe that, because we have gotten a lot of consumers complaining to us that they feel like the information that they've seen up there is not accurate.
Well, your point's well taken, and there needs to be a sorting out of the various fees so we clearly understand which ones are being bundled in and described as being one thing when in fact they're the other. It's a point well taken, and in our follow-up questioning we'll do that. Mr. Neymar.
Only thank you for the opportunity to participate. We have no further comment.
Thank you. Mr. Kelly, you've been here a long time. You've been a very busy witness, and is there anything that you'd like to say before we wrap this hearing up?
No, Chairman Kucinich. Thank you for your time. And obviously, if there's any additional documents, we'd be happy to provide it as we have in the past.
Well, I know that this has certainly been a difficult time for NAF, and occasionally institutions in our society proceed in a way that sometimes they get the legal system at another point takes a different view of it, and then everything changes. And obviously, things are happening like that for NAF. What we're trying to do with this committee is to look at how these practices in arbitration affect consumers with these mass debt collections. And if you put yourself in the position of a consumer who may not be getting proper information and may not really know what's going on, it's going to be a very tough time for a lot of people. And then you get the issue of financial literacy, which is altogether a different issue, which another committee takes up. So this subcommittee is going to continue to be involved in this. We'll continue to send you some inquiries. That we'd appreciate your cooperation in helping us find out what we can do to try to make this system work better for consumers. Certainly with your experience, you're probably going to be someone who is in a position to tell us what can be done to make the system better. And so we appreciate you taking this time. I want to thank each and every one of the witnesses here for their participation. I'm Dennis Kucinich, Chairman of the Domestic Policy Subcommittee. Today's hearing has dealt with the issue of arbitration and the misuse of mandatory arbitration to collect consumer debts. This committee stands adjourned. put all this stuff together and take it back from you.